Hello, I am Professor Doug Berman of the Ohio State University Moritz College of Law, and I am extraordinarily grateful to Professor Hessick and everybody at UNC Law for this event and for providing this opportunity for me to talk about some of my ideas concerning Apprendi 20 years later. I can't quite believe it's been 2 decades already, but I really enjoyed the opportunity to think some more about this case and this jurisprudence. And fundamentally, my paper for this symposium is exploring what I kind of think is a somewhat deceptively simple question. And it's a question that I think, in many respects, goes to the very heart of the Apprendi ruling and why it was controversial and a lot of its subsequent jurisprudence. Second, I think it provides a kind of useful perspective on both the history of sentencing procedure and where we might want that procedure to reshape itself in the future. And that's really the third part of this that's going to be underdeveloped in this presentation. I'm not quite sure what the answer is to kind of a better sentencing jurisprudence framed around this simple question. I just know this question is the one I want to develop in thinking through where the future should lie with improved sentencing jurisprudence. So, with that kind of build-up, let me give you the question. The question is, are jury trials and heightened standards of notice and proof just a mere formality in our American criminal justice system? Or do we want to think about, do we want to apply these procedures as matters of fundamental and foundational importance? Let me repeat that because, again, it's the framing for what I'll talk about for the next 10 or 15 minutes or so. Do we want jury trials and heightened standards of notice and proof just to be formalities in our criminal justice system? Or do we think these procedures should be of fundamental and foundational importance? And of course, part of framing behind this, as probably many people watching this know, the vast majority of our criminal convictions come from pleas in state and federal systems, not from trials. And so, to the extent that we care about juries, to the extent we care about heightened standards of proof and the traditional trial criminal procedure protections, plea bargains make those go away in 95 out of 100 cases. And so if we really want jury involvement, if we really want heightened constitutional protections for defendants to be fundamental and foundational to our system, I think we need to be thinking about them at sentencing. And at some level, I think the way I pose the question is to seem to answer it, right? We tend to think of trial by jury, enhanced procedural protections as fundamental to our constitutional charter. They're mentioned repeatedly in our founding document. Trial by jury shows up both in the body of Article 3 and in the Sixth Amendment. Other procedural protections show up throughout the Bill of Rights. The Supreme Court, of course, have talked exactly in these terms about these procedural rights being fundamental and foundational. The Supreme Court in Duncan versus Louisiana stated that, quote, trial by jury in criminal cases is fundamental to the American scheme of justice. And in Re Winship, the court described proof beyond a reasonable doubt as a, quote, bedrock, axiomatic, and elementary principle whose enforcement lies at the foundation of our administration of criminal law. And so I tend to take those statements at their word. I tend to think of these constitutional procedural protections as fundamental and foundational. But in fact, if you look at the history of sentencing and sentencing jurisprudence in this country, we don't see these ideas. We don't see these protections playing critical roles. In fact, we see some other wordy terms, what I'll use here as formalism and functionalism, driving sentencing and sentencing processes much more than these sort of fundamental foundational concerns about jury trials and heightened standards of notice and proof. We've seen throughout our history this formalism, this functionalism, not just being central to the work of courts, but being central to other actors as well, legislatures, sentencing commissions, and the like, don't approach the sentencing process as a setting in which jury trials, jury involvement, heightened standards of proof, additional criminal protections that we take for granted at the trial stage. The instinct is not to apply that at the sentencing stage. And what I think is going on in these settings, and I'll talk about this a little bit by discussing some major Supreme Court cases leading up to Apprendi and then a little bit more about Apprendi, is that there's a tension and I think an understandable challenge in affording those rights at sentencing and at the same time trying to get sentencing right. The way I've been inclined to phrase it for these purposes is courts, legislatures, sentencing commissions are much more concerned with getting it right at sentencing than with respecting rights at sentencing. And often when defendants assert a claim to a certain kind of constitutional right at sentencing, courts and others perceive that as an effort to prevent getting it right at sentencing. And so there's this tension and uncertainty about how can we respect rights and still get it right. And more often than not, historically, at sentencing, the state has prevailed. Courts have rejected claims for enhanced procedures at sentencing, and I'll talk about some of those cases leading up to Apprendi. To me, Apprendi was the sort of watershed moment, using the language of Justice O'Connor in dissent, where respecting rights didn't exactly dominate, but took on more of a stature. But because of this historical tension, because of this historical challenge between getting it right at sentencing and respecting rights at sentencing, it's not surprising to me that the Apprendi shift did not persist, and we saw a continuation and a jurisprudence where courts continued to want to prioritize functional, efficient, and effective sentencing procedures rather than respecting rights, looking at a jury trial, looking at jury involvement and heightened standards of proof as foundational and fundamental to that stage of the criminal proceeding. So let me, with a little time I have left, talk a little bit about some of this history in the full paper. I try to go into it perhaps in too much depth as we see case after case highlighting these tensions. And one of the things I'm eager to talk more about throughout the symposium is whether this framing, functionalism and formalism being kind of the historical norms and problematic, and then foundationalism and fundamentalism being the direction we ought to think about or explore where our sentencing procedures could go. So a little bit of history, too quick, but highlights formalism, defined things at the founding, of course. Originally, there were fixed sentences. So whatever you were convicted of, whatever your crime, that led immediately to the sentence. Formally, there really was no sentencing. And so, interestingly, the Supreme Court itself, in Apprendi, mentioned in a footnote that juries actually had some more of a role at sentencing because they knew, generally speaking, about the relationship between a particular conviction and a particular sentencing outcome. They could convict of a lesser offense or even nullify if they thought that that sentence was potentially too harsh. And so in the formalistic era, there was a tendency at least to give juries and traditional trial procedures a little bit more of a kind of practical role. But that era didn't persist. In fact, the next era in American sentencing was what's often described as sort of the rehabilitative era. The rise of penitentiaries, the rise of a notion, as articulated by the Supreme Court in this famous case called Williams v. New York, that the punishment should fit the offender rather than the crime, that we were trying to make sure that each sentence was tailored to the rehabilitative prospects of an offender. We cared a lot about making sure offenders didn't do it again. We created parole boards and a whole discretionary mechanism for both judges and parole officials to decide, what information they needed to get in order to come up with the right rehabilitative sentencing. And in this era, defendants sometimes complained, the most famous case again being this Williams case that got all the way up to the Supreme Court, of judges relying on information that wasn't presented at trial, that wasn't subject to trial protections. In Williams v. New York, it actually involved a trial judge imposing a death sentence after the jury had recommended life based on information that was in a pre-sentence report that the defendant hadn't seen, that the witnesses hadn't been subject to cross-examination or any confrontation. The defendant in William complained about that and said, what about my constitutional procedural rights when the judge is making a sentencing decision? And the Williams court very much, I think, focused on this idea of getting it right in a rehabilitative-oriented sentencing, said, and I'll quote here, individualizing punishments have made it all the more necessary that a sentencing judge not be denied an opportunity to obtain pertinent information by a requirement of rigid adherence to the restrictive rules of evidence properly applicable to the trial. In other words, and it's interesting to see how the court, kind of almost demonized this traditional criminal procedures, rigid adherence to the restrictive rules of evidence properly applicable to the trial. Well, there you get your right to trial, but here at sentencing, it's so important that we get the right sentence. that we individualize the sentence for you, defendant, that we're not going to respect your claim that you have some traditional rights to confront the folks who are bringing in evidence, or that the evidence that's being used to consider the right sentence under those circumstances. Williams not only is significant because it upheld kind of a rehabilitative oriented approach to sentencing that put no restrictions on the information that a judge could consider, but that precedent has remained good to this day. That precedent, among other things, is the foundation for the Supreme Court eventually in Booker making the federal sentencing guidelines advisory. But at the time, and again, I think it's so important to understand about Williams and cases from the Supreme Court of that era, the court very much thought this was good for defendants. The court, in fact, spoke quite glowingly of the idea that a rehabilitative model of sentencing is one that might allow a judge with this additional information, might allow a parole official with additional information to let a defendant out of prison sooner, right? The language the court used, it was to highlight that in investigations by pre-sentence officials, probation officers, that's not used to prosecute. That's used to aid offenders in the court's terms. And so the notion here is, in a rehabilitative model where we're trying to do better for defendants, procedural rights kind of get in the way. And I often, in this context, analogize it to the sort of medical model that was often talked about in the context of the rehabilitative era. We're trying to treat the offender. And I think it's right, if we think about going to the doctor, that when we would talk to the doctor who we really think is there to help us, that we wouldn't want there to be all sorts of rigid rules about what information the doctor could get to help us be treated as a patient truly sick. That's the thinking, that's the approach, that's the kind of benign vision that drives the Williams Court. But importantly, as many may know, that rehabilitative model didn't persist. In the 60s and 70s, states, federal government, among them, the jurisdictions reformed their sentencing laws to move away from rehabilitation. In fact, quite expressly repudiated a rehabilitative notion of how sentencing should take place, what the value should be. Deterrence, retribution, incapacitation, a bunch of other philosophies took to the fore as states created sentencing guidelines, mandatory minimums, a range of different kinds of sentencing structures that were indisputably designed to punish defendants more, not to treat them. And then that leads to the next Supreme Court case that is in this line, and again shows the court prioritizing getting it right over defendants' rights. It was a case from 1986, McMillan. McMillan was the case dealing with the mandatory minimum. Pennsylvania had passed a 5-year mandatory minimum if the defendant, in conjunction with another crime, possessed visibly a firearm. And there's just no doubt this wasn't to rehabilitate a defendant. The Pennsylvania Supreme Court, in fact, quite expressly said, we've rejected rehabilitation. This is designed to punish and deter and incapacitate. And yet the Supreme Court goes back, when this case is appealed from the Pennsylvania courts to the Supreme Court, the defendant arguing, don't I have a right to proof beyond a reasonable doubt before I'm punished for this? Don't I have a right maybe to a jury trial? This is an element of a new crime that triggers a 5-year mandatory minimum. But the Supreme Court says, nope, you've got it wrong. Remember Williams? We said at sentencing, kind of anything can take place. The court emphasized in McMillan the appropriateness of giving states wide authority to devise whatever sentencing scheme made sense to them to deal with the problems of crime and punishment. Again, this notion of getting it right being more important than defendants' rights, though here now, getting it right is not helping the defendant. Getting it right is focused on the state trying to devise whatever they perceive to be the appropriate approach to punishment at sentencing. And so we see, as the philosophy of punishment changes, as I would say, the plausible justification for prioritizing getting it right over defendants' rights is melting away, as we're no longer trying to be sort of beneficent at sentencing, but we're indisputably trying to punish. And judges are being asked to find specific facts, whether it's in a guideline system or a mandatory minimum system, that links to a particular punishment. The Supreme Court is saying it's just fine that the standard of proof that Pennsylvania put in place is preponderance of evidence. It's just fine that this is not a jury trial, right? And here, a little formalism comes into the functionalism. The court emphasizes in McMillan this idea that this is not an element. The Pennsylvania legislature decided to call this a sentencing factor. And that's just fine, because as long as it's not something we call an element, we won't require proof beyond a reasonable doubt. We won't require a jury trial. And again, that's just making up terms. Functionally, this is having an incredibly profound impact. But again, the functionalism isn't the defendant's concern, according to the Macmillan Court. The functional concern is, let's have states have broad authority to choose their approach to sentencing without, in the words of the court at one point, constitutionalizing burdens of proof, right? The instinct is we ought not encumber states that want to figure out the best way to punish folks by having these traditional trial protections. But this is where I get back to my initial question. That's a statement in some direct way that trial by jury, proof beyond a reasonable doubt, heightened standards of notice and proof aren't fundamental, aren't foundational to our system if we're going to allow punishment that's based on a lesser standard of proof, even in settings where we are punishing rather than trying to be rehabilitative in orientation. Last but not least, and I know my time is running short, I want to wrap it up. The Watts case in 1997 is the most dramatic example of the court playing this out. The Watts case involved a defendant under the federal sentencing guidelines being subject to an enhanced punishment based on conduct underlying a trial charge on which the defendant had been acquitted. And the Supreme Court says, again, relying on Williams, relying on Macmillan, the Supreme Court says again, oh, good enough for government work. That's just fine. It's so important under the guidelines to calculate the guidelines right, to get that right, that the fact that the defendant had been acquitted is inconsequential for purposes of figuring out what's required trial procedure, or what's required sentencing procedures. All of that is sort of the high water mark of putting getting it right over defendants' rights. Then along comes Apprendi. Apprendi, as I see it, is the ultimate example of sort of these tensions playing out. And it had been gurgling for some time through a series of cases, but the Supreme Court, I think, or at least 5 justices on the court, ultimately decided this has gone too far. And what to me is most notable and so interesting about the Apprendi decision is the way we see Justice Stevens articulate the need for a different ruling in foundational and fundamental terms. We actually see an echo of this 4 years later when Apprendi gets extended into Blakely, and Justice Scalia, likewise, is talking about Sixth Amendment protection, some of the language that Justice Stevens uses, which I think are, telling. This is a matter of simple justice, the court says in Apprendi, involving constitutional protections of surpassing importance. We have to look at the historical foundation of these rights, and rights that were to guard against a spirit of oppression and tyranny, and as the great bulwark of our civil and political liberties. This rhetoric, and ultimately the ruling in Apprendi, is let's put defendants' rights over, in a sense, getting it right at sentencing. It's so important to protect these broader fundamental constitutional procedural principles. We need to elevate them over this instinctual desire to just get the right sentence, regardless of what procedures that we use. Unfortunately, or notably, Justice Breyer says, well, wait a minute, this is going to make things really hard. This is not going to allow us to get sentencing right, and that's what's most important. We see this in his dissent in Apprendi. We see this in his dissent in Blakely as well. Likewise, we see Justice O'Connor in these cases saying states have been working so hard to get it right through guidelines, to get it right through structured sentencing systems. This is going to disrupt their ability. And again, I think there's just this fundamental tension and this fundamental challenge between, do we think sentencing should be just about getting it right, or should it be a setting in which we should respect and give effect to these fundamental and foundational notions? With limited time, I just want to emphasize the point. I'm on the side of we should be trying to give effect to these fundamental and foundational sets of concerns. I actually think, and this is the way I'll try to put it all together, that getting it right at sentencing is only really meaningful and only really efficacious if we respect rights in the sentencing process. And so for me, that means certainly not using acquitted conduct at sentencing, but I'm eager to figure out and eager to keep working through as part of this draft and in my own work what more that could mean. I actually think we kind of do this a little bit more in the capital sentencing system, which is really interesting. We have jury sentencing. We have a series of protections that are built around jury sentencing that I think do respect procedural rights a heck of a lot more than we see in other areas of sentencing. And whether that should be a model is something that I'm still working my way through, but that's fundamentally what I'm doing in this context, which is trying to figure out not only why we haven't given foundational and fundamental importance to these rights at sentencing in the past, but understanding what we might be able to do, how we can both principally and pragmatically be foundational and fundamental in our commitment to these constitutional protections of surpassing importance. Thank you.